first, much more. I know how important that is right now.
All rise.
Court number 237, Class A King.
Yeah.
Just a couple of matters, a couple of questions on the issue of what the matter is for the purpose of Section 4. We didn't really look at it yesterday, and certainly not today, but if you can go to page 2051 in the Learned Friends case, where they define the matters that they say could be arbitrated, they pass them up, disaggregate them. The second matter is the breach of the understanding, which we've debated. I've made my points about that. But the first question is, you can see how difficult it is to formulate a matter, because once you're outside the realms of what is 3, which is simple, you start to have to work out how the court looks at this. And the way it's defined is not, in fact, what you would need to know for the winding up. It's not about a lack of probity giving rise to just a loss of confidence. You can see that how it's defined in the passage here. It's not about a justifiable loss of confidence, and it's not about what that often morphs into, which is a question of oppression. And these are all sort of conclusions about the facts. And what they've done is they've isolated the factual issues, which they think is all that matters, but not done any sort of qualitative evaluation. And so we say that can't be within any form of test that you end up with as a result of tanning, because all they've really done is taken factual issues. They haven't taken the question, the right, the subject matter, the liability. I'm sure you're familiar with it, but it's always the case we start with here, Locke and John Blackwood, which is at page 4699. And it may be that the loss of confidence element of this is due to the fact it was a small company. It was a family company. And it may be that loss of confidence isn't, in fact, an appropriate question when you're dealing with commercial counterparties, because loss of confidence deals with Westbourne Gallery, deals with small companies. But when you're dealing with oppression, for example, as in Tian Rui, you wouldn't be talking about a loss of confidence as such necessarily. But Locke and John Blackwood was about a family company that resulted from, the people who were involved in this were the children and nephews and nieces of a Mr. John Blackwood. And Mr. McLaren, who I think was the son-in-law, or the sister's son, you see at page 786 how the petition is then, there's a complaint between the various children that are left. And at the bottom of 786, in the petition for winding up, 8 different reasons are assigned. First is statutory conditions, balance sheets, and so on, what I mentioned to you before. And then on 787, McLaren refused to go to arbitration, but the principal ground for the petitioner is that the circumstances to be laid before the court, it's just and equitable, the company should be ordered to be wound up. This last ground was affirmed by the court. And with regard to the three submissions, and then he's looking at all the things about the books and so on, and then he says at the bottom of page 4703, this is Lord Shaw, in their opinion, however, elements of that character and the history of the company, together with the fact that a calling of a meeting of shareholders would lead admittedly to failure and to be unavailable as a remedy, cannot be excluded from the point of the court and in the consideration of the justice and equity of pronouncing an order for winding up. Such a consideration ought to proceed upon a sound induction of all the facts of the case, shouldn't exclude but should include circumstances which bear upon the problem of continuing or stopping courses of conduct which substantially impair those rights. So they're looking at all sorts of things that happen in the administration of the company that aren't done properly. And then when they look at, Mr. McLaren takes matters too far, or at least that's how all the facts seem to them, at page 4710. You can see, in the opinion they formed of Mr. McLaren, for reasons not unnatural, come to the opinion that the business owed much of its value and prosperity to himself. He went on to feel that the business really treated it as his own and so on. He didn't give any dividends. And then he was upset about the testamentary arrangements of the brother-in-law and so on. So it actually, what happens is that he behaves in a high-handed manner. And you see that from a whole series of events, some more serious than others. So the question of lack of probity is often a very broad question in terms of the facts you're looking at. And if you're passing up issues, you lose sight of the fact that what you're coming up with is a judgment about lack of probity. And justifiable lack of probity in the context of what they say. And that is what makes it just and equitable to wind up the company. So in other words, the entire question of just and equitable is subsumed in this, your finding that it is justifiable lack of probity, so that it renders it just and equitable to wind up. That's essentially the usual way that these petitions are proved on that basis, or oppression. And my point, my Lord, is not that. My point is simply that if you're looking at a matter, it makes sense that you're looking at the entire question, not individual bits of it. And if you're looking at individual bits of it, you will have a fragmentation of a winding up petition, which is potentially infinite, because issues are infinite in a winding up petition almost. I mean, they're not so narrow. You'll put up your heads of complaint. You might even give particulars. But there's no telling what facts will be relevant or become relevant after the presentation of the petition. So that's really, I think, concludes what I wanted to say about matter.
Could I just raise one point of housekeeping, as it were, in relation to matter? In Tomalungan, the judgment of the Chief Justice refers to the Tanning case as having received wide acceptance and cites passages from Joseph on jurisdiction and arbitration agreements and Merkin and Flannery on the Arbitration Act. We don't actually have the pages that the Chief Justice cited in the parts, in the extracts from those books that have been reproduced in our bundle.
I'm very sorry.
No, well, I'm not critical of it, but it would be helpful for us to have them if that could be arranged.
Absolutely can be arranged. Just let me see if
it was, he cites pages 332 to 334 of Joseph and page 18 of Merkin and Flannery.
I see, and it might just be worth looking at the case at 5993, which is a decision of Mr. Justice Blair, and he deals with the same topic at page 5002. And this, I think, is not discussed in the more radical English cases. Not discussed, but 35, you can see he also refers to Joseph when he says that tanning is, you see at the bottom of 5002, paragraph 35, having referred to Dean, and accordingly, a similar approach is suggested in Joseph. We can certainly let you have that
Thank you.
overnight.
5102.
Sorry, what?
5002.
5002, paragraph 35.
What's the name of this case?
It's called PTTs.
BTT.
PTTs. It's page 4993. You can see, sorry, the front page. It's referred to in our case, paragraph 96. But the point we make in our case is that Mr. Justice Popplewell seems not to have looked at this because he doesn't deal with. I mean, he's referred to tanning. He might have been referred to the cases, but he doesn't discuss them in his judgment. And we'll get you Joseph, and anything else that your lordships want on tanning, we'll find. So on procedural and remedial issues, your learned friend has taken you to the recent English cases. Our submission is that when you deal with remedial, more or less impotence at some cases, and procedural chaos, we would put it in other cases. And I say it in this way because at their extreme ends, these concepts, we say, are capable of affecting arbitrability. We give examples in our case at page 2098 and 2099, subparagraphs A and B on that page. They're US cases, examples of extreme procedural problems and extreme remedial difficulty, when you're more or less deprived of your remedy in either case. Even in Fulham, which is then used for these propositions in other cases, the language is quite tentative. If you look at, right. In Fulham, what Lord Justice Patton says about this is they're not necessarily decisive, and he says that at paragraph 84, page 3759, these jurisdictional limitations on what an arbitration can achieve, and he's there talking about remedial difficulties. And he doesn't have any remedial difficulties in this case, because you remember it's conceded that the arbitrator could make the relevant orders under the FA rules. But he says they're not decisive. Doesn't say they're irrelevant to the question of arbitrability. And if you look at the earlier point when he's dealing, I think, with procedural issues at page 3745, he says something along the lines, I believe, of the not necessarily the answer. Yeah, he says that by letter E, not necessarily determinative of the question of arbitrability. So he's not putting it in categorical terms in Fulham. It becomes more categorical in the subsequent cases. But it's certainly not consistent with Fulham, and it's certainly not consistent with US law to say that these questions are never capable of affecting arbitrability. And as my Lord Kitchen put it yesterday, it's a strong thing to tell someone that by entering into an arbitration agreement, they've foregone a pretty natural statutory remedy. It's a different, I mean, Eres Ale was about a limitation statute biting and therefore losing that in a side wind. But to tell someone that the arbitration agreement excludes all sorts of claims is a different animal, we suggest, in nature. We say equally surprising that a matter should be arbitrable, even though the procedural complexities would defeat all the aims of an arbitration. In a winding up, as I've said, you're likely to have endless successive arbitrations if you've got big commercial counterparties. Those are likely to be arbitrations measured in years. You can't accelerate them. You have no jurisdiction as a court to hurry people up. In an arbitration, you can't refuse a stay, on my learned friend's way of looking at issues. And so procedural problems of that extent, which we say are very likely to occur on a just and equitable winding up petition, ought to incline you to look at the matter as less arbitrable. And that was the view that Justice of Appeal Ricks, who I'm sure you agree knows a thing or two about arbitration, seemed to think in page 967. In argument, he didn't give a real judgment in this case, as you know, but he was certainly fairly lively during the argument and made a couple of remarks, and one of which I'm going to rely on, which is at page 967. He deals at line 28, well, legislative policy. Everyone's in favour. Once you're in an area, this is at line 33, in an area which public policy reserves to the court, by which he means the remedy and the opinion. The question which we've just asked you about fragmentation is highly relevant. You simply within the area of arbitration with no public policy pulling in another direction, and the spot you give to arbitration drags other things within it, if you like, if you own a trust, that the parties don't want fragmentation of their disputes. And that's really the point we've been trying to make, that when you've got procedural complexity, it is inconsistent with the idea of a rational business person to allow fragmentation. That goes to arbitrability, but obviously I made the same submission in relation to how you look at the matter. Sorry, I lost my... And, you know, the procedural complexity and fragmentation and the delay also have to be taken in the context of a petition which seeks to put a stop to ongoing misconduct, lack of probity. And there's almost always at least, if not urgency, there's some need to have that resolved, get the divorce done and dusted, get someone independent in to deal with the company. That's the object of a winding up petition. If you spend 8 years in arbitration, which is what we're looking at, we've already had a 4-year delay from presentation of the petition. You undermine the whole purpose of the proceeding. And that's a legitimate consideration when you're considering arbitrability of a winding up petition. I mean, you saw, that's one of the reasons I showed you yesterday, they're still at it, point, up to 2018, and that there was still, they were intending to carry on like that. They were intending to grow the company. There was no regime put in place to protect our rights in the interim. There's no provisional liquidator. We wouldn't have got one. And in the end, all these complaints are met with the refrain, well, this is the consequence of party autonomy. But that autonomy is premised on what a rational businessman would do. That is the whole point of the autonomy. It's the idea of someone agreeing to things. And what is being ascribed to the will of a rational businessman is really the need to squeeze everything into arbitration. Squeeze a square peg into a round hole. And that can't be right, we say. So these considerations, especially procedural chaos, are very relevant to arbitrability. My learned friend relied on Tomalugan for both the remedial and procedural issues. Tomalugan, you remember, the arbitrators, the Singapore Arbitration Act, I can't remember, one of your auditors pointed this out to my learned friend yesterday, gave the arbitrators wide powers. You'll see that at page 6649 in Tomalugan in paragraph 97. So there wasn't, in fact, a real problem. Paragraph 97. We don't agree jurisdictional limitations on a tribunal's ability are relevant. We would point out the Singapore Act confers wide remedial powers on arbitral tribunals. And then they adopt a statement in paragraph 98, which goes over the page, 6650, from Mustle and Boyd, that this is an issue of jurisdiction. And you remember my learned friend put it like that, and that's the way it was put in Fulham, rather than arbitrability. And the reason is because it's the arbitration agreement that sets out so the argument goes, it's the arbitration agreement that sets out the remedial difficulties. But of course those problems, the problems of the arbitrator, the remedial difficulties in arbitrator are because he can't make orders in rem, he can't affect third parties. That doesn't stem simply from an arbitration agreement. Those are limitations which are inherent limitations on any arbitration. So it may go to jurisdiction, but it also goes to arbitrability because the arbitrator simply can't do certain things. And if those are central to the type of claim you're making, that ought to affect arbitrability because it completely undermines the purpose of the remedy being a winding up order that changes status and that other people are bound by, an order in rem. So the fact an arbitrator can't make that order is relevant to the question of arbitrability, we say. And Tom Alugan's answer to it is we say, not sufficient. On terms of procedural complexity, they start at 6652. And the difficulties that they outline are set out in paragraph 104, securing the attendance of witnesses and documents and so on, and the possibility that the court might disagree inconsistent judgments. Those sorts of difficulties are a mere trifle with what we would have in complexity, which would be the successive coming back to court, more arbitrations, coming back to court, more disputes that have to be the subject of a stay. And the other cases to which you were referred, the English cases, later English cases, on these topics, are not dealing with that level of complexity. They're not dealing with a similar question. They're dealing with They're not even dealing with third parties in the main. And Bridge House is one, but in Bridge House you could come back, you could go to court with the finding to bind third parties. It's not the same objection as having to do successive hearings on evidence. Malone and Friend says, oh, well, this is frequently dealt with in case management. We're very clever at this. Ingenious solutions are devised. And we say that glosses over the problems that remain and can't be solved with case management. The court, first of all, you have to remember the court has no discretion if there is in Malone and Friends, on Malone and Friends test, a Mozambique issue. And if that turns up after the arbitration, there's no discretion. You have to go back to arbitration if you allow that issue to be raised. You can't control that issue sensibly by withholding and granting leave to amend. If a new fact relates to an issue, then it quite possibly, it may have to be pleaded. Perhaps you can force it to be pleaded. But amendments are supposed to allow issues to be ventilated. It's supposed to allow parties to resolve the matters in dispute before them. So the idea that the court can refuse leave to amend simply so as to avoid a stay seems rather odd. That's not the purpose of granting or refusing leave to appeal. That's in effect a disguised way of avoiding or embracing a stay. And if the court says no to the issue and refuses leave to amend, then it artificially limits the party from including the issue. And if you say, well, we'll give you leave, but you then have to go off to arbitration, you haven't solved the procedural chaos. I don't think, with respect, those sorts of case management tools don't help you deal with the fundamental problem of procedural difficulties. Because you end up either telling a party he can't say you've done it again, and forcing him to go to trial without that additional fact. Or you force him into another arbitration. On the one hand, you've artificially limited the issues. On the other, you've given way to the chaos and the multiplicity of proceedings again. That doesn't solve anything. Or the price of solving it is artificially high. You can't manage third parties. In Tomalugan, if you just have a look at page 6683, in the ordinary case, you can't just accuse someone who doesn't want to participate in the arbitration of abuse of process, which is what they're suggesting in 190D. C and D, if you look at that, what they're suggesting is that those investors who decide not to participate in the arbitration would then be subjected to some form of abuse of process argument. But that's somewhat outrageous, given that they haven't agreed to an arbitration. It seems to have been influenced, this suggestion, by a finding that the management participation allegation was a narrow subsidiary issue. And then you have to ask, how would the court address res judicata as regards the non-arbitrating defendants. When you go back to court. I mean, for example, you have more than one victim of a breach of fiduciary duty. One of them arbitrates, the other doesn't. What happens if the wrongdoer challenges that decision? How does that bind, the finding bind the other victim? And then there are disclosure problems, because if you have an arbitration and there are other parties, you can't, even if there aren't other parties, you can't necessarily assume that the documents disclosed in an arbitration can be used in proceedings, or vice versa. Most the ICC rules allow a party to withhold consent to that. But you have procedural problems which you can't manage simply in the way my learned friend suggested. And if you look at some of the directions in Tomalugan, they seem either unfair or inadequate. That only arises, these are submissions I make if you're against me on, well, they go to really the question of how you look at the matter and partly how you look at arbitrability. I think they're made separately by my learned friend, but they go to both questions. The obligation to make a stay, to give a stay, is in section 4. Can I just ask you to look at the wording of that, because it's page 2191. If any party to an agreement, forget for the moment person claiming through under him, commences proceedings against any other party in respect of a matter, any party to the proceedings may, after appearance, apply for a stay. The idea of this section, I'm going to submit, and I have Court of Appeal authority that suggests I'm right, is that this allows one party to an agreement to obtain a stay against another party, and a mandatory stay. It doesn't mean that they can't get a discretionary stay against other parties, but fundamentally this is about mandatory stays. And my submission is that that Ting Chuan can't get a mandatory stay of the petition against the company. And the petition is a proceeding against the company. And I'll show you in a moment why that has to be the case. So that particular provision, which is the same in England, was considered in the Court of Appeal in England in a case called Mayan Citizens of City of London, which is at 3443 in Sanchetti. It's about the defendant took a lease. Parties agreed to submit to the non-exclusive jurisdiction of the courts. Claimant brought proceedings for rent arrears, and the defendant sought a stay of the proceedings on the ground that, as an Indian national and an investor and lease of premises, he was entitled to invoke the arbitration provisions in the bilateral investment treaty between the government of the UK and India. And the argument was, his argument turned in large measure about whether or not he was claiming through or under, and you'll see that. But the relevant discussion starts at 3449, where Lord Justice Lawrence Collins refers to Section 9, which is the same form as the section I've read out to you, in the Cayman legislation. I've no doubt that Section 9 cannot, and this is 3450, paragraph 29, cannot apply if the parties to the court proceedings are not the parties to the arbitration agreement. Be wholly inconsistent with the purpose and structure of the 96 Act in general, and Section 9 in particular, if a stay could be obtained against a claimant who is not a party to the agreement. The fact that Section 9 refers only to a party to an agreement against whom legal proceedings are brought in respect of matter doesn't obviate the need for the claimant also to be a party. It's not sufficient that there simply be a matter referred to arbitration. So here the issue was whether the claimant was a party, but the same point, the obverse point is also true of this passage, that the person seeking the stay must be a party for the mandatory stay to work. The defendant seeking the stay, the defendant and the claimant. Now, the fact that the defendant seeks a stay, in this case, as against us, doesn't mean it is entitled to a mandatory stay in relation to the proceedings against the company. That's the argument. There's a case called, which is not entirely the same either. There's a case called, this was considered in relation to a winding up petition, where it seems someone wanted to intervene to stop the petitioner, i.e. a party wanted to stop a non-party. It's not the same issue as here. The relevant, the case is, sorry, 1 second. Called Re Fenox, it's at page 3612. Decision of a seems to be. Lost my a relevant passage. You can see on page 3612. It's a decision of a deputy. Page 3613. The third respondent to the petition, supported by the second, to join an additional party to serve the proceedings on whom the application joined is not pursued. Then there was an application for a stay, and the relevant passage starts at page 3618. And I'm going to take this quite quickly because it's not the same as this case, but it's a winding up petition. It's a company petition to which the original parties were the petitioner and Fenox GmbH as sole equal shareholders, and the company itself. None of these is a party to the partnership agreement or any other arbitration agreement. Abazov has been added, and then it was Abazov who claimed the stay. In any case, jumping down a few lines, in any case, the joint of Abazov doesn't entitle him, let alone Fenox, to see a stay under Section 9 against the petitioner, and then he relies on the judgment of Lord Justice Collins. So it's applied in a slightly different way against, to say that the claimant who wasn't a party can't be stayed. But the point I was making in relation to the Court of Appeal judgment is, if you take the proposition that you have to be, the logic of the section as the mandatory stay operates in respect of parties to the arbitration agreement, the company is not a party. So the result of that would be that we would have Ting Chuan that could claim a mandatory stay and would seek a discretionary stay in relation to the company. And in relation to the company, if there's a discretionary stay, we would want to be at least able to elect whether or not to proceed as against the company and perhaps as against the directors. Because as you will have seen from the summary of the facts, it's the directors who control Chuan. It's the directors who have all the relationships with the related parties. So we would at least want the opportunity to rethink the petition to see whether we should continue with the petition against the company and perhaps seek to join others. Chuan would have a right to a mandatory stay at this stage. I'm assuming against myself that it does. And if you accept that, then you have no discretion in the matter, but you have a discretion in relation to the company. And we say, given the fact we've already had an arbitration, the amount of time that's elapsed, and the possibility that we might be able to have an effective means of relief by pursuing the company, we would at least ask for you to allow us to elect whether or not to do that, rather than forcing us into discretionary stay in our petition against the company. It may be that those instructing me would elect to put everything into arbitration, but it doesn't follow that you have a duty to stay the proceedings as against the company, and if that's the case, we say that circumstances now are such that we ought to at least have the right of election. There's an argument, I think, that was put to my learned friend, well, isn't the substance of this that this is a proceeding against the two shareholders, it's not a proceeding against the company at all, so it's not relevant that the company is a party. And I wanted to show you a decision of Mr. Justice Siegel in the Chan Rui case, which is at page 2834. This was a case where we had a petition had been issued against the company alone. It had proceeded for some time as a petition against the company alone, and then at some stage we decided that we wanted to join the people that had been responsible for the dilution, we say. And the question of who was the characterization of the petition and the proceedings, as well as the basis of joinder, were all discussed in this rather lengthy judgment. You can start by looking at page 2843, in which there's a judgment set out of Mr. Justice Feinlott, and the judge has underlined the relevant passages. And the point of this is that this is all about joinder, and he says a petition under 459 is about 5 lines up from bottom, not analogous to litigation, which the issues raised affect only those against whom allegations are made. Close analogy is to an administration action. Practice has so far been followed to require all members to be joined, all members to be affected to be joined. Small private company, you join all people. So this is about the reason you have characterization in most cases is because of the issue of costs. The reason you need to know whether the proceeding is in reality a proceeding against between two parties is because you don't want one of the parties in control to be using the money in the company to pay their own defense. And sometimes the reason for joinder is because you want the people accused of wrongdoing to become parties so that they're joined to the petition and they have a chance to defend themselves and you have a chance to get discovery against them. On page 2855, he refers to passage in Joffe on minority shareholders. The company must always be joined as a respondent to the petition. usual to join all members. The point being that not only is it usual, but in this case, it had been how the petition had proceeded for quite a long time, and the other shareholders joined on the basis that the company should defend the petition on its own. And what the court did in the end was it allowed the joinder, but it allowed the company to participate in the proceedings. So the company was allowed to defend the case as it saw fit. It was entitled to participate just as a trustee might be entitled to participate. It may be that in those circumstances it doesn't do very much. It may be in other cases it does. It may be that if it does something it wouldn't be entitled to an indemnity for its costs. But the point is that the company is a party to a winding up petition. It always should be a party to a just and equitable petition. It's the subject of a just and equitable petition. And so it can't be right that on the question of Section 4 of the Foreign Arbitral Awards section, you ignore the fact that the company is the party. In order for my learned friend to say that it is simply, it is claiming through or under someone else, there's a whole other debate that has to be had, and the Australian cases I showed you are relevant to that. And they deal with the question of whether a claim is through or under, and they deal with the Rusev case that Lord Justice Collins dealt with in Sanchetti. We didn't have that debate. I put it in our case that we put in our case that that wasn't an argument that was made below. The fact is that the company isn't entitled to permanent stay, and Ting Chuan isn't entitled to stay in relation to the petition. So we could get rid of the allegations of undertaking. We could, for example, get rid of, if we elected that, to do that, to get rid of the allegations of causing and procuring the directors to do so. Maybe that we would never succeed in doing that, as they are the owners of that company. The fact is we can reform the petition to be based on lack of probity, if we wanted to. Which is why it's important to look at that to remember that that is, in a way, the primary allegation, because the others are subsidiary on it. And I don't have instructions to do that. I'm simply saying we ought to have the election. If you decide that you're going to stay the proceedings, because otherwise, save for that point, Ting Chuan is entitled to a stay.
So are you saying that although the winding up petition can be characterized for case management purposes as inter partes proceedings between the shareholders, that doesn't turn the proceedings in reality into proceedings falling within the terms of Section 4 of the Foreign Arbitration Act?
That fact doesn't turn it into that proceeding. What we have is that we have a characterization which is reached for certain purposes. It's reached primarily for cost purposes. Yeah. But and it might be accurate to say in real general terms, well, that is the proceeding. But on the other hand, the mandatory stay doesn't get them to that point. And then they'd have to say, well, that's not that, you should give them a discretionary stay because of that, to which we would say, well, you should give us the opportunity to reform our allegations, and then it won't look like that anymore. Because the main players are the Way brothers. They're not the companies. They own the companies. So although we've accepted that for cost purposes and everything else, discovery, the proceedings are between the joint venture parties, it doesn't follow that it's impossible for us to proceed in a meaningful way with the petition on another basis.
Yeah.
And given given the fact we've already participated in a delay, and given the fact that the tribunal expressly said on a number of occasions that we really don't get on, and that we ought to have a divorce, we say there shouldn't be an exercise of discretion for a discretionary stay. So I'm sorry I've taken up quite a lot of time. I know I had more time, but can I sit down, because I'm really at the end of my football knowledge and everything else. Okay. Thank you very much.
Yes, Mr. Kimmins.
My lords, I won't be long at all, I'm glad to say. Can I start with matters? We say, as I submitted yesterday, the correct approach is Mozambique. We note in passing the relatively granular approach that was taken in Fulham. We need to turn it up, but if one looks at paragraph 94 at 3761, you can see that one of the matters was whether Sir David had acted in breach of duties. So that's consistent with the granular approach. We do say that Mozambique is the right approach because it must include, we say, as a matter of logic, something like a critical preliminary issue. So let's test it against that. Assume that an issue arose. Did A make a representation? And that may be part of a critical estoppel or misrep claim, but it's a critical, simple, factual point. Now that may be a very important point, and it would be crazy, we would say, if that could not qualify as a matter. Now, it's not entirely clear to us where Tanning would stand on that question. I'll come back to Tanning in a minute. But what we do say is it has to be able to carry and cover an issue of that nature, because it would be incredibly useful, obviously, to be able to hive off something which would ordinarily qualify as a preliminary issue. Brackets, whether or not that qualified as a right or liability. As soon as you start getting into that type of language, query whether you would be able to cover something like a preliminary issue, which might be incredibly useful. So turning then to Tanning, we do still wonder what my learned friend's case is as to what it means. And what he says the requirement for a right or a liability actually involves. And again, you can test it in many ways, even leaving aside a preliminary issue. What about a simple question of construction of a clause? You may not be, at that stage, considering breach. You say, what does that mean, that clause? Does that qualify? This is the problem with Tanning, is that you end up with lots of difficult questions which arise, which wouldn't arise if you had the simpler approach in Mozambique. We also wonder how one gets there in terms of the Tanning test from the statutory language. It is an enormous gloss, we say, on the statutory language to start reading in that terribly complex sentence into the word matter. And so we do wonder how one gets there simply as a matter of construction. As to some of the old authorities, my learned friend relies on Re-1-ins as being an old and useful authority, he says, on how to approach a matter. But we would point out that Re-1-ins was expressly referred to in Fulham. And I gave you the reference yesterday. Apologies, I can probably dig it out again. But you'll recall at the beginning of Fulham, when it lists the cases referred to in skeleton arguments and all the rest of it, you will see Re-1-ins listed in Fulham. So that was clearly before Lord Justice Patten, and yet he obviously adopted a granular approach despite that. Now, the easiest answer, of course, is that even if you apply the Tanning test, it still covers matters 1 and 2. It still, obviously, we say, would cover breaches of directors' duties, procuring breaches of directors' duties, and the ever-present understanding. And my learned friend, entirely justifiably, tries to play down the influence of the understanding in this case, because I think he recognizes that it leaves him particularly vulnerable on this point. But if one looks at every single complaint that is made in the petition, it is also alleged to be a breach of the understanding. And the references there are paragraphs 55, paragraph 80, paragraph 82, paragraph 109, and paragraph 110. Every one of those allegations is based on a breach of the understanding. In addition on tanning, you have the Hydrox case, which we say is a simple and thoroughly rational application of the tanning test to a situation such as this. And you'll see what the Australian High Court did. It said it's wrong to suggest that the only matter is whether it is just and equitable to wind up, and you must get more granular. And we say they were absolutely right. And my learned friend criticised the reasoning of Mr. Justice Foster in that case, but we thought it was rather good, personally. There's 2 or 3 pages of analysis, and they go into it in some detail. His real point on matter is to try and bring in fragmentation and procedural inconvenience by the back door. And we've argued about that in relation to arbitrability, long and hard. But the fragmentation point in relation to matters is likewise expressly dealt with in the authorities. See Popplewell J and Carr LJ, and the references are 4162 and 4163, where they deal with the fragmentation point and inconvenience point, specifically in relation to the matters issue. And of course, you also have Andrew Smith J in Lombard at 3894, and he also deals with the procedural inconvenience points relating to the matters issue, and makes much the same points along the lines of there are means of dealing with this, such as generous construction of arbitration clauses and taking a decision not to stay the remainder of the proceedings. There is some criticism of the way in which we have identified the matters in our written case, but in relation to that, we have simply based it on the language in the petition. They are directly linked, and you can see in the footnotes to our written case exactly where the points come from. So we haven't left anything out, we don't think, and we haven't added anything else in, we don't think. It directly reflects the petition, and that is why we have formulated the matters in the way we have. Now, if I'm right on matters, and I'm not going to say anything more about those unless you'd like me to, then that is the end of the case, we say. That it's matters or bust. And that is for the following reason, that if I focus on matters 1 and 2, which is what I'm going to do, if you'll forgive me, I'm not going to press 3 and 4. I don't make any concession in relation to that, but we don't think we need 3 and 4. And therefore, we would invite the panel to focus on 1 and 2. If we focus on 1 and 2, and we're right on matter, then there is no case on the statutory exception, because one never needs to look at the effect of the words, the court is of the opinion that, because we can see that on that hypothesis, that's all for the court. And therefore, no point arises on the statutory exception, and you're then left with the public policy point, which my learned friend, in fairness, didn't really press. And so where does he have to go? We say nowhere. And indeed, one might ask, at that stage of the analysis, where does procedural complexity come in at all in relation to the arbitrability point on matters 1 and 2? It can't help him on statutory construction because of for the reasons I've just mentioned. Public policy, my learned friend, doesn't push it. So it doesn't really come into play at all. But nonetheless, even if you do refocus on procedural inadequacy, remedial inadequacy and procedural complexity, I just want to develop one point, which I mentioned yesterday, and I want to show you one short passage from an authority. I repeatedly said, if it creates problems, tough. And my learned friend said, well, that's very unsatisfactory. And what I should have said is what Lord Justice Mustell said in the Iras case. He said, if that creates problems, that may seem tough, but it's not. And that's the point he made. And I just want to show you that at page 4184. And this is from the mists of River Rock. So just to give you that reference again, that's 4184. And River Rock is a decision of Mr. Justice Foxton. And in the midst of that decision, sorry, I'm getting there rather slowly, you have a summary of that case in paragraph 59. And it's interesting the way it's addressed, because essentially the point he's making is not that it's tough on the party who will lose his remedy, but that it would be terribly unfair on the other party if they were to be deprived of the benefit of the clause which they've negotiated, their arbitration clause. So it turns it on its head. So you'll see it's also clear, however, the mere fact the party's chosen tribunal would not have power to entertain a cause of action or grant relief available in proceedings in a foreign court does not of itself have the effect that the foreign proceedings fall outside the arbitration agreement, nor that anti-suit relief is not appropriate. They then refer to Fulham and Lord Justice Patton. And then they refer to the case I mentioned yesterday, Iras Isle. A stay in favour of arbitration under Illinois law in Illinois was resisted on the basis it would deprive the respondent of the ability to claim under the Civil Liability Contribution Act. Lord Justice Mustill stated, Section 1 of the Act requires the court to grant a stay unless there is no dispute between the parties or the arbitration agreement is null, void, inoperative, or incapable of being performed. These words do not apply here. Nothing has gone wrong with the arbitration agreement. All that has happened is that the parties have discovered that the remedies available to the arbitrator are in one respect more narrow than those which, but for the agreement, could have been awarded by the English court. We can see no ground here for refusing a stay. At first sight, and this is my response to being teased about it being tough, at first sight this result appears harsh, but the impression is misleading. It is not a question of Clarkson's being deprived of a right by the grant of a stay. On the contrary, the parties have agreed that all their rights shall be fixed in Illinois according to the procedures and by implication the substantive law in force in that state. If the stay is refused, and the consequence will be that by acting in breach of their agreement and pursuing their claim against Howden's in the English court, Clarksons have obtained for themselves the possibility of a right and remedy which they would not have possessed if they'd acted as their agreement required. In the face of this, we can see nothing unjust in holding them to their agreement. And similar points are made in 61. So that's Iras Isle, and why we say it's tough but fair. A couple of other points just to pick up before I move on to discretion. My learned friend took a point on Tomalugan at page 6649. Just wanted to make a short point on that. If one could get up 6649. And if we could have a look at paragraph 97. The point that was made was that the IAA confers wide remedial powers on arbitral tribunals. And there's a reference to 12.5 little a of the IAA. Just for your note, precisely the same provision is in the Cayman Act at section 57.2. Now, unfortunately, that's not in your bundle, but we will make sure it's added. So it's materially identical to the provision referred to in paragraph 97 of Tomalugan.
That's the 2012 Act.
Correct. Correct, my lord. Now that brings me on to the final point, and I promised I'd be quick, and I will be, which is the discretion point. Now, the key point to remember is that you are here to consider whether this petition should be stayed. And it's all very well, my learned friend, saying, well, I may want to bring a different petition, but the correct analysis on that hypothesis is that you would grant a mandatory stay as against TC in the ordinary way. If you didn't grant a mandatory stay as against the company, I'll come back to that point. If you didn't do that and were simply granting a discretionary stay, you would do that. And my learned friend, if he wants to then reformulate and redraft his petition completely, get rid of all the allegations against TC, get rid of the allegation that he wants a buyout from TC, he can reformulate that if he wants. and he can then apply to lift the discretionary stay. But it's to put the cart before the horse to say, well, the correct analysis is actually don't grant a stay against the company at all, brackets, in anticipation of a new petition which my learned friend might choose to formulate and serve. So the correct analysis is stay it, and he's not prevented from applying if he wants to. Obviously, my clients would reserve their rights to, frankly, say whatever they want in response to it. But my learned friend is entitled to make that application if he wants, and that's the way to deal with it. So we say that point is very straightforward. In terms of whether to grant discretionary stays in this case, and whether or not, as a result, you need to get into the nuts and bolts of who delayed where and when and how, we say you never need to get into any of those questions, because the issue of stay, insofar as it arises, is incredibly straightforward. There are only 2 or 3 scenarios which arise. Scenario 1 is that matters 1 and 2 are arbitrable, and matters 3 and 4 aren't. And it's conceded that there would be a discretionary stay of matters 3 and 4. So that's discretionary stay number 1, not in dispute at all. Then you've got discretionary stay against the company, and I've touched on that already, but we say there must obviously be a discretionary stay against the company because there are no allegations against the company. The company is not the protagonist. And indeed, the whole petition is defective insofar as it purported to be a petition against the company and the company alone. It seeks entirely different relief, in other words, relief from TC, and alleges a breakdown in the relationship between FM and TC. It's all about FM and TC. There's nothing to do with the company at all, and therefore it has to be the subject of a discretionary stay, and then my learned friend can reformulate if he wants to, and proceed on that basis. I should just say that there are lots of cases where discretionary stays have been granted against the company when the company was not a party to the arbitration clause. And they are, first of all, revocam, the one I showed you yesterday, where you'll recall the words they used in the judgment were, once you remove the shareholder from the battle scene, there's no point in continuing against the company, and therefore discretionary stay granted. 4 other cases in the bundle in which discretionary stays were granted against the company, despite it not being party to the arbitration agreement. Tomalugan, see paragraphs 3, 10 to 13 at 6617 to 6619. Quicksilver, paragraph 2 at 6092. Vedanta, paragraph 2 at 6847. And Re-Via Networks, C 6115 to 6116. These are all cases where there was a discretionary stay granted against the company.
Sorry, what was the one you mentioned before, Tom? You pulled it out before your list.
That was revocam.
Oh, yes.
And just to give you that reference, I mentioned it yesterday,
Yes.
decision of Mr. Justice Reimer, 4341 and 4342. So the argument, don't proceed against the company because he's not the real protagonist and the shareholders removed from the battle, is at 398, and accepting that argument is at 399, which is page 4342. So there are many cases where that has happened. If you bear with me, it may well be that that's it. Yes, sorry, I am reminded, one point, yes. Lots of points were made at the beginning of my learned friend's submissions yesterday. We, perhaps unsurprisingly, do not accept any of those allegations which were made. Rather than me boring you by taking you through the pleadings at great length, what we'd like to do, with your lordship's permission, is to put in a one-page document simply giving you the references where the allegations which were made orally are denied by my clients in the defence.
Yes, can you give us that, say, within the next 7 days?
Certainly, certainly. And one other point, just in relation to what I might say, what might be described as prejudice points made by my learned friend. It's true that we lost the ICC arbitration in which allegations were made against the other side, but of course, as the bench has already noted, the allegations against my clients weren't part of the ICC arbitration, and they could have been. And we rather expected there to be a counterclaim. And if there had been, we wouldn't be here. So there we go. My lords, unless I can help you further, that's all I was going to say in reply.
Thank you very much, Mr. Kivens. Well, we're most grateful to counsel on both sides for the quality of the submissions we've received. The case is a good illustration of the importance of some of the issues that are raised in appeals from the Cayman Islands to the Privy Council, and the result of the case may well have a resonance beyond the islands themselves. We'll take time now to consider what we've heard and the advice that we will humbly tender to His Majesty the King.